Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in today's session I want to talk to you about data protection and Brexit and some of the implications. It's very easy, I think, to think about us having left the European Union in terms of things like, do we export to Europe? Are we sending physical goods there? What we may not think about quite so often is where we're sending data, and that's what I want to focus on today. In fact, there are implications also in recent developments for anyone who's sending data outside of the UK to the US as well. So if you remember back in 2018 when we were going through our audits for GDPR purposes, when the GDPR was coming in, we were perhaps auditing what data we had, what we were doing with it, who we were sharing it with, where we were sending it to. I mean, we may well have identified at that time that we were sending some data outside of Europe and oftentimes to the States. That might even be because we're using certain pieces of software that are based in America that, administer, I don't know, a pension scheme or a benefit or, for some purpose is using data. So, for example, I use MailChimp to mail you all. That is a US hosted site, so I will be uploading data to the US if I use that site. And back in 2018, if we were doing as we were supposed to, we were notifying data subjects, so individuals, about what we were doing with their data. So we were giving them privacy notices, and we may have said in those privacy notices that we were relying on something called the US Privacy Shield, which essentially was an agreement between the EU and the United States about the level of protections going on in those two continents about data protection. So essentially, the EU was saying it was safe to send data to America. Now, if you've been a close follower of these things, you may know that there's been some ping-ponging back and forward around the issue of to what extent the United States is a safe harbour. It's one of the bits of jargon that used to get used for such data. But the Privacy Shield was supposed to be the answer and to mean that we could all rely on sending data there. Development in 2020 was something called Schrems 2. And essentially what has happened now is that the powers that be in Europe in terms of data have decided that for reasons concerning things like national security and the extent to which the American security apparatus may look at data and access data from Europe, they weren't prepared to give that stamp of approval any longer. So we can't rely on that privacy shield. And I'll come on to what we need to do about that in a second. So that's development number one. Development number two is, where are we with Europe? So we may not be sending goods to Europe, but we may well be transferring data back and forward. So we might have a host for something that we do that's in another European country, or we may have a group company. We may be owned by a parent company in Spain, or we may have a German subsidiary, and there may be data flowing within our group of companies back and forward to those countries. Now, since we left Europe, we have become what's called a third country. We're no longer part of Europe, so we count as an outsider, essentially, for data protection purposes. Now, the big hope was that Europe would grant us this kind of approval I was telling you about for America, that they haven't given America anymore, to us in what is called an adequacy decision. So they would be saying that we're quite happy with the systems that the UK have in place around data protection, because of course it's based on the same system as us, because we all had the GDPR as our foundation behind our data protection legislation. The wheels were put in motion for that in advance of the 31st of December, but it probably won't surprise you to find out that we ran out of time and that adequacy decision has not been made. As a result of that, what has happened is a sort of holding pattern has been put in place, a temporary arrangement for 6 months. The hope is that the adequacy decision, which has been drafted, or consultations and paperwork is in the process of going through all the machinery of data protection approval in Europe, that we'll get that at some point in the spring. The hope being then that we don't run out of time in this 6-month window. If that happens, then we'll be fine. Everybody will be able to carry on doing what they're doing. If for some reason that is delayed and we fall outside of the temporary window that's been created, as in it takes too long, or for whatever reason we don't get an adequacy decision, then we will be back to the position of those who are trying to send data to the US. And essentially, if there isn't an adequacy decision, then we need to enter into special contracts with anyone that we are sending data to outside of the UK, outside of Europe, with us being the outside country. Now we've left Europe, then we need to have these special contracts in place. It gets abbreviated to SCC, these special contractual clauses. Now, again, what has to go in these SCCs is ruled by European data protection bodies. So there are these sort of framework documents in existence already that have been around for a long period of time that are kind of approved at European level. They're in the process of being updated. So drafts of that have gone out for consultation, and things like the European Data Protection Board have commented on it. And publication is expected shortly. Our Information Commission has published tools around SCCs. So there is a whole section of guidance on their website, particularly for SMEs. There's a hotline as well for help there. But certainly those who are very involved in data protection are advising us all to plan for the worst and then will be organised, rather than leaving it for the 6 months and then suddenly finding that we haven't got the adequacy decision that we thought we were going to get, and then panicking to put these contracts in place. For example, one organisation had to put in place 3,000 of these documents, just to give you an idea of the number of parties that you might be sharing data with, or you might have to have one of these agreements with. So it is worth just thinking about, what are we doing on this issue? Auditing, first of all, what data we are sending outside of the UK now. And that will include Ireland, of course. So if you have got branch offices, a sister company over there, you will need to be thinking about this as an issue. As ever, if you've got any questions, adenton@refreshinglawltd, as in the shortened form of limited.co.uk. Thank you very much.